Good afternoon, Mr. Gani.
Good afternoon, Chief Justice. Good afternoon, Commissioners.
How are you this afternoon?
I'm well, thank you, Chief Justice.
Thank you, thank you. We are all fine. We apologize that you have had to wait quite a bit for your time to come in. But if we could have done quicker what we were busy with, we would have, but we couldn't. I'm going to put certain questions to you, and when I'm done, I'll ask the acting judge president to do the same, and then I will allow, after that, the MEC who represents the Premier, and thereafter it will be the commissioners who will get a chance to put questions to you if they have some questions.
Thank you, Chief Justice. I understand.
Yes, everybody will put questions to you with a view to seeing how your appointment would meet the selection criteria that this commission has approved if you were appointed. So I will start by looking at your academic qualifications. I see that you hold 3 degrees. It's a BCom degree and a LLB and a master's in law, which you obtained cum laude, is that right?
That's correct, Chief Justice.
And you obtained all these 3 degrees from the University of KwaZulu-Natal.
That's correct, Chief Justice.
Your BCom you got in 1996, LLB in 1998, and then LLM you completed it in 2003.
That's right, Chief Justice.
Is that all right?
That's correct.
And you were admitted as an advocate in 1999.
In July 1999. That's right, Chief Justice.
Yes.
Sorry, April of 1999.
Yes. And then you started practicing as an advocate then, and you continue to practice as such.
That's right.
Okay. And you took silk in August of 2019?
That's correct, Chief Justice.
Yes. But I see that you also lectured part-time at the University of KwaZulu-Natal between 2003 and 2008.
That's right. I was a part-time lecturer in corporate law.
Yes. Okay. So that's the fact that you admitted in 1999, July, would mean that you have been in practice for about, what, 21, 22 years?
It's 22 years, almost 23.
Almost 23. Okay. Tell us about your practice over the years.
Yes.
What types of cases have you been doing, and what branches of law would the cases you have been doing in your practice fall under?
Yes, Chief Justice. As I tried to explain in the questionnaire, my practice fell into what I could call a few phases. I came straight from university. So over the first 2 to 3 years, it was a case of taking whatever work one could get. And over those years, I did criminal law for the Legal Aid Board, matrimonial work, motion court work, and so forth. Around about 2003 or so, my practice changed slightly, and that was for 2 reasons. One was I began lecturing, and the other was I was invited to join a group in Durban. The suggestion was that there was a need for young juniors in Durban. I took up both those opportunities, and from thenceforth, my practice began to change. Because I was lecturing, I began to receive more corporate law work, tax work, commercial work, and from Durban, I received quite a few junior briefs. That went on till about 2010 or so. And by that stage, my practice had reached the stage of what I could call senior junior. And principally, my principal areas of practice now, as they were from 2010 to 2012 or so, are constitutional and administrative, pension law, and corporate law. That's where it was when I applied for Silk, and that's where it is now, Chief Justice.
So it's a variety of branches of law.
Yes, there's certain branches of law I don't get briefed in.
Yeah.
For instance, matrimonial law or criminal law.
Yeah.
But for the rest of it, it's civil, focused on those 4 or 5 areas that I've described.
Yes. And you have, are there cases in which you have appeared as counsel which have resulted in reported case judgments?
That's correct, Chief Justice. I've put a few of them in the application, and there's certain of them in my CV as well.
Yes. And how long have you acted as a judge in the High Court in KZN? If you put together all the acting stints, to what period would they more or less come?
They come to 7 sessions. The sessions vary between 4 to 6 weeks. So that would be 7 sessions would roughly be about 35 weeks or so, somewhere there.
Yeah, about 35 weeks or so. Okay, and when you have been acting, what kind of branches of law have you dealt with in the cases that have come before you?
Yes. Chief Justice, in the civil sessions, one would do opposed motions, the motion court, civil trials, criminal appeals. There were lots of criminal appeals, urgent matters. And then I did one full criminal session, which involved a criminal trial from the start. That's the entire trial, conviction, sentencing, and in that session, criminal appeals and bail appeals. So it was probably the full range of what would be expected from a judge that would be a permanent judge over those 7 sessions.
Have you sat in full bench appeals as an acting judge?
I did. In fact, I sat in one last month as a civil full bench appeal, full court appeal, in which I wrote the judgment.
And how much motion court have you done, both opposed and unopposed, in terms of weeks?
A lot, Chief Justice.
Yeah.
In a session of, say, 4 to 5 weeks, an acting judge would probably get roughly 4 motion court sessions. So for each civil session, I would say on the average 3 to 4 motion court sessions.
In terms of your judgments as an acting judge, are there judgments you have written that have been reported?
I have marked 2 judgments as reported. Chief Justice, those are the 2 that I've attached to the questionnaire. For the rest of them, some may have featured on SAFLI, but I haven't marked any others as reportable.
Yeah. About how many written judgments have you produced as an acting judge up to now?
Chief Justice, I did a rough tally. If one had to include the extempore judgments, the written judgments, and reasons that were given after an order were given, they would be in the region of 40 judgments.
Yes. What do you understand by the rule of law?
The rule of law is the principle provided in Section 1C of the Constitution, which simply stated means everyone is subject to the law. The example that is given is that the president is, and as is the ordinary citizen.
And what is your understanding of the doctrine of separation of powers?
That is the principle that divides the arms of state, that is the executive, legislature, and the judiciary, into 3 categories, each of which has independence, and none of which can intrude upon the territory of the other. Simply put, from a judicial point of view, judges can't make law because that is the domain of the legislature, nor can judges get involved in matters of policy because that is the domain of the executive.
And what is your understanding of the independence of the judiciary?
Yes. Judges are subject to the Constitution. They take an allegiance or swear allegiance to the Constitution only, which means that they must decide cases according to the law, regardless of who appears before them. The fearless application of the law.
I will now give the acting judge president the opportunity to put questions. I must say, Mr. Gani, that I appreciate that you seem to be quite crisp in your answers. So, acting judge president, I give you the opportunity to put questions to the candidate.
Thank you, Chief Justice. Mr. Gani,
Judge President.
do you regard education and training as an effective tool for a judge in the performance of his or her duties?
Judge President, I do participate in the judges training course as well. So judicial education is important.
So, according to your view, what are the benefits of continuous training for a judge?
Yeah, a variety of things, Judge President. The law is constantly changing. There may be new practice directives which judges may not be exposed to because the matters one get depends on, it's uncertain. Matters are set down and judges don't know what matters they're going to get. So if there's continuous education, certainly judges that have not encountered a particular aspect or particular field can be educated about that, and that could assist when they do get matters in the future.
So, you have acted for some time. Is that
I have,
correct?
Judge President.
So, is there any area of law where you feel that you still need more exposure?
Judge President, on balance, my answer is that with my experience as a practitioner and with the experience that I've had over the 7 terms, respectfully, I think I would be able to handle any matter that may be allocated to me. From the sessions that I've done, I've only acted in 1 criminal session, and as you know from my application, I'm not briefed regularly in criminal matters. But even that said, for the 1 criminal session that I have, I've produced the judgments and I've attached it. And my view, respectfully, is that I will be able to conduct any matter that may be allocated to me as a judge.
Okay, thank you, Chief Justice.
Thank you, AJP. MEC.
Thanks, CJ. First question. In the context of the independence of the judicial,
Yes.
do you think judges should accept invitations to address various platforms on topical issues in the public discourse, some of which may make a judge to express a particular opinion about a particular person or a particular policy position and still retain independence?
I think the first point would be that if a judge adopts or accepts that invitation, he or she should subscribe to what the Code of Conduct requires. I would be circumspect about what the judge should say. If a judge were delivering a lecture to a university, I would be inclined to say the judge should stick to matters of legal principle. Because even if the judge did not intend to intrude upon a policy aspect or an executive aspect, it can be perceived that he or she did so, and that can become controversial. So I have no difficulty with a judge addressing a particular audience, provided that there's compliance with the Code of Conduct, and the judge is circumspect about what is said.
Last one, SHA, having lectured part-time, as you indicated, but we have not really written for certain publications.
Yes, I lectured to the part-time law students, which was the evening lectures. So it was not part of that part-time post to produce articles or anything of that effect. The mandate or the employment was restricted to lecturing, setting the exam, externally moderating it, unlike a full-time lecturer.
Thanks, CJ.
Thank you, MEC. Commissioner Dodovu.
Thank you, CJ. Good afternoon. I want to follow the question that CJ asked you around the separation of power
Yes,
between different arms of government. What is your, do you know what judicial capture is? And if you do you see some elements of judicial capture in South Africa?
To deal firstly with the separation of powers, it's a separation of the arms of state. Government, to my understanding, refers to the government of the day, which is the executive, so to speak. You raised the question of judicial capture, you say. That is a difficult question. We know we have a body that's dealing with the issue at present. Findings will be made. Insofar as judicial capture is concerned, that would be a very strong allegation to make in relation to a particular judge. I recollect the former CJ making the point that if there's any allegation of judicial capture or any misconduct on the part of a judge, it should be reported. To my knowledge, and given the allegations that are in the public domain with respect to state capture, as we've experienced it or read about it in the last few years, I have not come across any credible complaint about a judge being involved as part of that, if I've understood your question correctly.
No, thank you very much. Asking on behalf of Honorable Nyambi, what about judicial overreach?
He's overreaching himself right now.
But Chief Justice, I was hoping I wasn't asked about judicial activism because that might generate some controversy.
Yes, okay, thank you. Commissioner Singh, you had your hand up? Yeah.
Yes, very, very crisply, Chief Justice. Good afternoon, Advocate Gani.
Good afternoon,
Just one, I see you've listed a number of referees in your CV. I take it all have been informed that their names are here on page 37.
Commissioner, the CV was updated over a period of time. For this particular round, for me being here, I must say I haven't called all of them. But previously I have spoken to them about being a referee on my CV.
Okay, you've got 10 listed there. Some very influential people. My question will be, are you aware of the existence of traditional courts in KZN, and what do you think their particular role is, and how efficient do you think they are in performing those roles?
Commissioner, I must confess I'm not entirely familiar with the traditional courts. I haven't had any experience or exposure with relation to them in my practice or as a judge, but I understand their role. They have a vested role under the Constitution, as does customary law, common law, and religious practices, and so on. They're regulated by the Framework Act, which provides for kinship and the extent of it. And there's a section, I think, of the Black Administration Act, or two sections, which still apply. The nub of the matter is that there is a need for adjudication and for disputes revolving a traditional community to be dealt with by people from within that community. There are appeal rights, such as to the magistrates' court and so on. And ultimately, in a constitutional democracy such as ours, that can continue for as long as it does not clash with the provisions of the Constitution, including the Bill of Rights. That's as far as I can take the answer.
Thank you, Chief Justice. Thank you, advocates.
Thank you. I'm going to go to the commissioners. Commissioner Matolo Zlepu.
Thank you, Chief Justice. Now that you spoke about it, I'm going to ask you, what do you understand about judicial activism?
Well, I have trepidation about that because there is this trend about judicial activism, but my difficulty with it is that it suggests that judges can enter the terrain of their own views on public policy when deciding a case. And it goes back to separation of powers. If judges are to decide a case, they must do so subservient to the Constitution only. Where policy issues are introduced into a judge's decision, then in my view, it contravenes the separation of powers doctrine. That was my trepidation about judicial activism.
Okay, thank you, Chief Justice.
Thank you, Commissioner. I'm going to the commissioners who are attending virtually. Is there anyone who has a question for the candidate?
No question from me, CJ.
Thank you, Commissioner Shabangu Mdawe.
No questions from me, CJ.
Thank you, Commissioner Barnard.
I have a question, please, Chief Justice.
Please go ahead, Commissioner Breitenbach.
Thank you, Chief Justice. Good afternoon, sir.
Good afternoon.
Under what conditions do you consider apposite and appropriate to consider in a recusal application for a judge, and what would you consider as necessary for you to recuse yourself in a matter?
Sorry, Commissioner, could you please repeat that question?
What are the elements that you would consider necessary in order to recuse yourself in any particular matter, either on application or mere motu? Thank you.
You mean you said recuse yourself?
Yeah, recuse yourself.
Yes.
So the question is, what are the requirements for you to recuse yourself in a matter?
Yes. One would look at the Code of Conduct for Judges, which speaks about when judges could have an interest in the matter. So that would be the guiding principle. Constitutionally, judges are obliged to hear cases except where there's a valid reason to recuse himself or herself. I can give an example of how I've dealt with matters in which I perceive that there might be a conflict. In one particular case, I had acted for the respondent, and for the applicant, I had held a brief at that time that the matter came to me. I immediately sent off a directive to both sides, disclosing to them, making a full disclosure about the briefs that I held and the matter that I previously represented the respondent in, and invited them to advise as to whether they believed I was required to recuse myself. In that particular matter, both sides came back and says they raised no objection. They were aware of the previous representations and that I could continue. But that just illustrates that where there's a semblance of any party being unhappy or perceiving that you have an interest in the litigation in the matter that you're hearing, a disclosure should be made. And that is how I see it, Chief Justice.
Thank you, sir. Thank you, Chief Justice.
Thank you, Commissioner.
Thank you. I have no further commissioners attending virtually wishing to say something, and I think it looks like we've come to the end of this interview. Thank you very much, Mr. Gani. We appreciate your making yourself available for consideration. I'm going to give you 3 minutes in case there are points that you would like, 2 or 3 points that you would like the commissioners to particularly consider when they consider your candidature. But if you feel that all issues have been adequately addressed, that will be fine as well.
Chief Justice, permit me to take the 3 minutes, and I think I'll honor the 3 minutes.
Yes.
Just a few points I'd like to make so that my application is understood. Firstly, before I actually applied for the position, I conferred with the Judge President at the time and advised him of my intentions, and I received his blessing, so to speak. I also conferred with the Acting Judge President, and he was agreeable to that as well. All of the judges of the division with whom I have worked have lent their support to me. So I simply make the point that for those of the judges with whom I have engaged, they appear to support my appointment to the KZN bench. The second point, and this is just a matter for updating, as it were, one of the judgments that I have attached to the application, it's State versus Mtumbeni. It's the first judgment in the pack. That was a criminal appeal. I simply point out to the Commission that since then there has been an amendment to the schedule. That's part 1 of Schedule 2 of the minimum sentence legislation. And the amendment takes into account precisely or substantially the issues of concern that we had raised in this full court, such as the rights of the victim. That's the second thing I point out to the Commission. I'd like to think that the judgment contributed to some aspect of the legislature considering the problem. And then thirdly, and this is just a matter in case it does feature, I see from one of the reports, it's the GCB, that makes reference to the composition of the KZN bench with respect to race and gender and so forth. And I make the point simply that if one looks at the composition, it comprises 10 black men, 5 white men, 3 Indian, and so forth. Respectfully, an appointment or recommendation of someone like me, an Indian male, would, as some of the reports say, not be contrary to transformation of the judiciary, and also be consistent, I think, with Section 1742, which deals with diversity. Those are my points, Chief Justice.
Thank you very much. You are now excused.
Thank you, Chief Justice. May I express my gratitude for the manner in which the interview was conducted.
Thank you.